Everyone for returning promptly. We can go back on the record. We'll begin with Mr. Harold Weinrich, and next up will be Elizabeth Bunn.
May
Morning.
it please the board. By way of introduction, I am Harold Weinrich. I am a member of the firm of Jackson Lewis. We represent employers nationwide in labor and all aspects of workplace law. I began my career in Region 29. I learned labor law at the knee, and too often over the knee, of a labor law icon, Regional Director Sam Cainard. I appear for the Atlantic Legal Foundation, a nonprofit, nonpartisan public interest law firm. The foundation's mission is to advance the rule of law before courts and agencies, advocating limited and efficient government, free enterprise, individual liberty, and the safeguarding of constitutional protections. ALF is concerned that the board's proposed rules threaten to undermine these core values. The board's rulemaking authority is strictly circumscribed. The board may only make such rules as may be necessary to carry out the provisions of the Act. The board may only adopt rules to implement the will of Congress, not as a means to further their own agenda. The board exceeds its authority when it seeks to refashion the Act. Here, the timing of the board's proposed rules, coming after Congress rejected statutory revisions now encompassed by the proposed rules, underscores the fact that the board may not seek to carry out the Act's provisions, but may rather intend to enact the changes that Congress rejected. The board's proposed rules do not respect the constraints Section 6 places on the board's rulemaking authority, and therefore the board is exceeding that authority. Today, I address some areas where the board deviates from its proper rulemaking authority. First, the proposed rule disregards the language of Section 9. The rules preclude the holding of any pre-election hearing, no less an appropriate hearing, with respect to many disputed and material eligibility and unit inclusion issues. These issues may not be heard or decided until after employees vote, and possibly will remain undecided. Ignoring Section 9's guarantee of an appropriate pre-election hearing does not carry out the provisions of the Act. It also ignores Section 7. Employees, when they vote, are entitled to know who is to be the collective in any collective bargaining. When individual or classification, eligibility, or unit inclusion issues relating to disputed supervisors remain undecided, not only is Section 7 and 9 ignored, but the employer cannot identify who is to communicate on its behalf, and thus its Section 8C rights are abridged. The board does not carry out Section 7 by rushing to the ballot box. Employees are guaranteed the right to have the information necessary to make an informed choice. The fact that making an informed choice may take time is a necessary feature of a democratic process. It is a core Section 7 right. Free and robust debate is an essential element of employee free choice, and a rule that infringes on that right is not sanctioned by Section 6. The board also does not carry out Section 8C by the proposed rules. That section gives employers the right to communicate with employees non-coercively concerning the exercise of their Section 7 rights. Unless an employer has an adequate opportunity to fully utilize its free speech rights between the time a petition is filed and an election is held, employees' rights are destroyed and the employer's free speech rights become meaningless. The Supreme Court, in the recent Brown decision, acknowledged this. An essential source of information and opinion, specifically protected by Section 8C since 1947, that is necessary to an informed employee electorate must not be neutered by a rule or rules radically limiting the pre-election period. The board should not alter the statutory scheme by enacting this proposed rule. In order to safeguard employee free choice, to continue to provide a meaningful opportunity for the agency to determine appropriate units, the board is urged to withdraw its proposed rule. Section 6 is not optional language, it is a command. Its purpose is evident. It was intended to prevent the NLRB from changing the will of Congress. Further, it is untimely for a board majority, which will soon be composed of only 2 members, one whom sits by recess appointment, to propose and consider any rule, especially such a far-reaching rule that substantially and fundamentally changes the provisions of the Act. I quote the chairman, "Recess appointments should be hesitant to overrule precedent because it could be seen as a rush to judgment and undermine public confidence. Recess boards should be caretakers and keep the railroad running and not make policy decisions. The proposed rules, if made final, will be precisely the very rush to judgment that the chairman predicted and will undermine public confidence in the board." Thank you.
Thank you, Mr. Weinrich. Of course, my colleagues in the board at that time who were recess appointments disagreed with me and made a lot of changes in precedent. Isn't that correct?
Unfortunately, Ms. Chairman, it is, and I think they should have agreed with you. I do.
Are there other questions?
Thank you.
I want to ask you one other question. You talked about the legislation that didn't get through Congress and how many of those provisions of the legislation are encompassed by these proposed rules. Well, as my understanding of the proposed legislation was that it had 3 major elements: improved remedies for certain unfair labor practices, mandatory mediation and binding arbitration of first contract disputes that didn't get settled, and provisions for certification upon proof of majority through card check. I don't see any of those in these proposed rules, do you?
No. However, Ms. Chairman, if we look at the legislation, if we look at the debate, if we look at the compromises offered and considered, the essence of the proposed legislation was to make sure that the election process moved forward more quickly and that the employer did not have sufficient time to speak. And that is certainly encompassed within the rule that this board proposes.
Well, actually, I think the legislation was about providing for another alternative to election process. And the outcry about the legislation was that it was superseding the secret ballot election process. Seems to me the essence of these proposed rules are to make the secret ballot election process work better. Wouldn't you agree?
The secret ballot election process can only work better if there is an informed electorate. And these rules take the time period, which has been the same for decades, approximately, give or take, 40 days, and cuts that, as Member Pierce suggested, down to 10 or 14. And that abridges the rights of employees and the rights of employers. The union, as we might know, has no direct right under the Act with respect to communication. It only has a derivative right, which makes me wonder how you suggest that they who do not have a right can waive the Excelsior list. Thank you.
That's another point. Thank you. Any other questions? Thank you, Mr. Weinrich.
Thank you.